Good afternoon, everyone. Thank you for joining us for today's Lead Center webinar, The New CMS Regulations on HCBS Settings, Implications for Employment Services. My name is Elizabeth Jennings. I'm the Lead Center Assistant Project Director here at National Disability Institute, and I'll be your facilitator today. We have some tremendous speakers joining us today, including Rebecca Ceylon, the Lead Center Project Director, Annette Shea with the Center on Disability and Aging Policy, Administration for Community Living at the U.S. Department of Health and Human Services, and Samantha Crane, a Policy Director at the Autistic Self-Advocacy Network. Thank you right away to all of our speakers for joining us today. We so appreciate your time and expertise on this topic. For those of you that are new to Lead Center webinars, the National Center on Leadership for the Employment and Economic Advancement of People with Disabilities, or as we call it, the LEAD Center, is a collaborative of disability, workforce, and economic empowerment organizations led by National Disability Institute with funding from the U.S. Department of Labor's Office of Disability Employment Policy. And speaking of the U.S. Department of Labor Office of Disability Employment Policy, I'd like to hand over the mic to my colleague, Speed Davis, for his welcome.
Thank you, Elizabeth. On behalf of Assistant Secretary Kathy Martinez, I welcome you all to the third webinar ODEP is sponsored about Medicaid waivers and their implications for the employment of job seekers with disabilities. There will undoubtedly be more as more guidance becomes available. The Center for Medicare and Medicaid Services is the federal agency responsible for administering the Medicaid waivers. They embraced the use of Medicaid dollars to support the employment of goals of people with disabilities. In fact, they've made employment a priority and are working with the states to ensure that employment services are included in states' waiver applications or amendments. Those of you who attended the first two webinars already know how difficult it can be to absorb all of the information published by CMS. So what you hear today is similar to information presented in the first two webinars, but we feel it bears repeating. Whether you saw the other webinars or are here for the first time, we hope that you will find the information from Samantha, Rebecca, and Annette to be useful in your work. Thank you.
Thank you so much, Speed. The mission of the LEAD Center is to advance sustainable, individual, and systems-level change that results in improved, competitive, integrated employment and economic self-sufficiency outcomes for individuals across the spectrum of disability. And as Speed described, we do this through webinars, training and technical assistance, and several LEAD Center initiatives. Before we go any further, we want to offer you a few housekeeping tips, and so I'd like to invite my colleague, Nakia Matthews, to share with you those tips.
Good afternoon, everyone. The audio for today's webinar is being broadcast through your computer. Please make sure that your speakers are turned on or your headphones are plugged in. You can control the audio broadcast via the audio broadcast panel, which you see here below. And if you accidentally close this panel or if the sound stops or becomes unintelligible, you can reopen it by going to the top menu item, Communicate, Join Audio Broadcast. If you do not have sound capabilities on your computer or if you prefer to listen by phone, you can dial the number you see here along with the meeting code, and you do not need to enter an attendee ID. I will also paste this information into the chat box. Real-time captioning is provided during this webinar. The captions can be found in the Media Viewer panel, which appears in the lower right-hand corner of the webinar platform. If you'd like to make the Media Viewer panel larger, you can do so by minimizing some of the other panels like chat or Q&A. And conversely, if you do not need the captions, you can minimize the Media Viewer panel. We will have a question and answer portion at the end of the webinar. Please use either the chat box or the Q&A box to send any questions that you have during the webinar to me, Nakia Matthews, or to Elizabeth Jennings, and we will direct those questions accordingly. If you are listening by phone and not logged into the webinar portion, you may also ask questions by emailing them directly to Elizabeth at ejennings@ndi-inc.org. Please note this webinar is being recorded and the materials will be placed on the Lead Center website at the URL you see below. If you experience any technical difficulties during the webinar, please use the chat box to send a message to me, Nakia Matthews, or you may email me directly at nmatthews@ndi-inc.org.
Before we hand off to our speakers today, we'd like to take a moment to frame today's conversation. As Speed mentioned, the Lead Center co-hosted 2 webinars on the new regulations with the U.S. Department of Labor's Office of Disability Employment Policy, CMS's Disability and Elderly Public Health Group at Employment First back in February. Both webinars and the related handouts are available in their entirety through the Lead Center webinar archives by clicking the links we've provided. When we post the archive of this webinar, we'll also post these slides. And if you'd like to check out these webinars before that's made available to you, you can always go on to the Lead Center website at leadcenter.org, and in the far right-hand corner, the top right-hand corner, click on Webinars, and you'll be able to link to these 2 webinars that we provided back in February. CMS is in the process of preparing and releasing additional guidance regarding transition planning, public input requirements, person-centered planning, applications of the settings requirements to non-residential settings, and changes to the 1915C waiver technical guide. And as that information becomes available, we'll be finding ways to share it with you through the Lead Center, which may include technical papers that are released or even another webinar. Today we're going to have 2 speakers help you understand some of the final rule and some of the other efforts that the Centers for Medicaid and Medicare Services are launching. Annette Shea with the Center on Disability and Aging Policy with the U.S. Department of Health and Human Services Administration for Community Living is with us today, and she's going to share information on the commitment of CMS and ACL to support improved employment outcomes. Annette, thank you so much for joining us today.
Hello?
Great. We can hear you loud and clear.
Okay, sorry.
No problem.
There was a beep, and I thought maybe I lost you. Do you want me to go forward?
Yes, please.
Okay, sorry. I just want to make sure you weren't going to introduce the other speaker. Thank you very much for asking me to join the call and to provide you with some critical information and impress upon you how committed HHS is and CMS in promoting employment. You know, the way we envision promoting employment is through a person-centered approach and through systems transformation. For HHS, the guiding vision for employment is that people with disabilities will have access to the services and supports they need to achieve successful employment outcomes, and they won't need to choose between health care and work. Through a person-centered approach, an individual is empowered to make informed decisions about their personal goals and objectives about employment, including decisions about long-term services and support options consistent with their personal goals, and assistance navigating the various organizations, agencies, and other resources in the community. When promoting employment, we encourage partners to consider how employment is promoted and supported from the individual's perspective and at a systems approach. For example, consider scenarios of successfully employed individuals with disabilities and the supports, steps, and milestones needed for them to achieve their success. What are some of the common threads? Are there strategies, supports, and services which contributed to that success? Are those elements reflected in state philosophies, systems, and approaches? What happens when individuals achieve their employment goals and economic well-being? Do they have access to the critical health care supports needed to live successfully in their community? Are there services and supports provided in an integrated setting consistent with the HCBS settings rule? And consistent with those guiding questions and principles, HHS and our federal partners have a number of initiatives which promote successful employment outcomes for people with disabilities. AIDD, which is the Administration on Intellectual and Developmental Disabilities, Partnerships, and Employment, what we refer to as the PI grant, is intended to prioritize employment as the first and preferred option for youth and young adults with IDDD. Grantee funding enhances collaboration across existing state systems, including programs administered by state developmental disability agencies, state voc rehab agencies, state educational agencies, and other entities to increase competitive employment outcomes for youth and young adults with IDDD. Also, AIDD Communities of Practice on Employment, the Institute for Community Inclusion leads the creation of a national communities of practice comprising 5 states to build capacity across and within states to reform current employment systems that will increase competitive and inclusive employment for individuals with intellectual and developmental disabilities. The Medicaid buy-in program is an optional state Medicaid program in which working individuals with disabilities with income and earnings above traditional financial eligibility thresholds for Medicaid have access to critical Medicaid benefits. 45 states currently have active Medicaid buy-in programs with more than 200,000 enrollees. Some states implement the program with no restriction on income or assets. Most states, however, have policies with income and asset limits. The PROMISE initiative, which is PROMISE stands for Promoting Readiness of Minors and Supplemental Security Income, is a $211 million 5-year grant to 5 states and a consortium of 6 states to establish and operate model demonstration project designed to improve the education and employment outcomes of child supplemental security recipients and their families. And I also want to point out that we do collaborate with ODEP on a few of their initiatives that you're probably already familiar with, so I won't detail. One is the ODEP Employment First Leadership Mentor Program, and the other is the ODEP Disability Employment Initiative. And so we consider them our strong partners in the area of employment, and we're happy to partner with ODEP in promoting employment also through systems and individual approaches. The ADRC No Wrong Door Part A grants were awarded to 8 grants, and they're known to be the ADRCs are known to be the No Wrong Door, a single entry point, and are designed to serve as highly visible and trusted places available in every community across the country where people of all ages, incomes, and disabilities go to get information and one-on-one counseling on a full range of LTSS options. Nationally, ADRC programs have taken important steps by creating person-centered, community-based environment that promotes independence and dignity for individuals with disabilities and elders. The model promotes employment through counseling and providing relevant information to individuals and their families. As we have moved forward with the development of this model, the term No Wrong Door is now more regularly recognized and used and applicable to the work happening in the states. And just recently, there is a No Wrong Door funding opportunity announcement. Just recently, ACL, CMS, and the Veterans Health Administration released a funding opportunity announcement to assist states in the planning of a No Wrong Door system to help individuals access long-term services and supports. The goal is for the No Wrong Door system to make it easier for people of all ages, disabilities, and income levels to learn about and access the services and supports they need. The No Wrong Door system will also provide states with a vehicle for better coordinating and integrating the multiple access functions associated with the various state-administered programs that pay for LTSS. The funding available is to support state-led 12-month planning process and to identify key actions the state will need to take to move forward with the development and implementation of a No Wrong Door system. The expectation is that the No Wrong Door system and the person-centered approach will include employment components within the business models through the use of training, education, and information about employment and formal linkages to employment services and supports. The Balancing Incentive Program is a CMS-funded program that increases the federal match to states to make in order for them to make structural reform changes to increase nursing home diversions and access to non-institutional LTSS. The enhanced matching payments are tied to the percentage of the state's LTSS spending, with lower FMAP increases going to states that need to make fewer reforms. So we have one state, Mississippi, who is receiving a 5% enhanced FMAP on certain LTSS services. All the other states, which I think there are 18 other states now, there's a total of 19, all the other states receive an enhanced 2% FMAP. States can use the enhanced FMAP to promote employment through their No Wrong Door structural change system, and by requiring the use of the enhanced FMAP for the purposes of expanding or enhancing access to community-based services and supports for Medicaid beneficiaries. This could include employment supportive policies and supports. Money Follows the Person rebalancing demonstration helps states rebalance their Medicaid long-term care system through the use of enhanced FMAP for rebalancing activities and administrative support for infrastructure change. MFP promotes employment by increasing access to HCBS services, including employment supports and services such as benefits counseling and peer supports, and supported employment, integrated employment supportive policies and practices within transition coordination function, and supporting the development and inclusion of employment supportive information within state long-term care systems. MFP also provides employment-related technical assistance to state grantees and measures participants' interest in participation in employment. In regards to the HCBS settings rule and its applicability to the non-residential settings and services, CMS is in the process of drafting sub-regulatory guidance for non-residential services and supports, which will include employment services. CMS is also drafting guidance for states' transition plans as they move toward compliance with the new settings rule. Those guidance documents should be ready later this year. And that's all I have.
Great. Thank you so much, Annette. For those of you who are on the line, we really appreciate Annette coming on and joining us today. If there are some questions that you have about some of the comments she made or some questions about maybe some of the acronyms, please know that you can be putting your questions into the Q&A box now or into the chat box, and we'll compile them and ask questions of our speakers at the end of the event today. Thank you so much, Annette. We really appreciate your time with us and feel that there will be several questions for you come the Q&A period.
And, you know, they can also have my contact information if maybe in a future date if they have questions as a follow-up too. And if you have that, if you want to provide that, I'm fine with that too.
Great. Thank you so much.
All right. Thank you.
So we're now going to invite Samantha Crane, an attorney with background in disability law, and she's the Director of Public Policy at the Autistic Self-Advocacy Network, to provide a third-party assessment of the application of the settings requirements to non-residential settings. We do want to take a moment to advise those of you on the line, the almost 600 people on the line today, that the views expressed in this webinar are based on the speaker's expert analysis, that CMS has not yet released their analysis, and so what we're sharing with you does not necessarily reflect the views or policies of the Centers for Medicaid and Medicare Services or the U.S. Department of Labor's Office of Disability Employment Policy, nor does the mention of trade names, commercial products, or organizations imply endorsement by the U.S. government. But as Samantha will explain to you, CMS has often utilized the analysis of experts in the field to help them in framing their technical releases, and so we're very thrilled to have Samantha Crane with us today to give her expert analysis of this final rule to support all of you as you continue to do your efforts at the state and local level. Thank you, Samantha, so much for joining us today.
Hello, can everyone hear me? We can hear you loud and clear. Great. So I'm just, we've now just switched to this slide that was basically summarizing what you just heard, that my views are as a third-party expert, and they do not reflect the views or policies of the Centers for Medicaid and Medicare Services. The Medicaid final rule that we're going to discuss today was originally published in the Federal Register on January 16, 2014. It was designed to ensure that services provided through home and community-based services funding through Medicaid and Medicare are actually community-based and actually reflect the priorities of the funding stream. It applies to all HCBS provided through the Community First Choice Act, state plans, or HCBS waivers. So it's a variety of funding sources, but anything that is covered through Medicaid or Medicare, home and community-based services funding is going to be covered by this regulation. The rule is going to apply, in fact, is already being applied to all new 1915C waivers and 1915I state plan amendments. States are required to submit a transition plan when renewing or amending waivers or state plan amendments. Alternatively, they have to submit a transition plan within 1 year of the effective date of the final rule. If they do not have a renewal or an amendment due before March 17, 2015, then the transition plan is due on that date. The key deadlines for all 50 states are going to be available on hcbsadvocacy.org. Now, the time frame means that many states, the regulation came into effect in March 2014, and that means that many states are already having to submit their transition plans. We've already, as we're going to see later in this webinar, some states have been waiting for further guidance from CMS, and some states are sort of charging ahead based on their own interpretation of the final rule that was published on January 19th. So we feel that this is sort of a good opportunity to give more insight to key players in terms of what CMS might be about to come out with in terms of guidance, so people can know better what their obligations are. The basic requirements of the new final rule is that first, HCBS must be provided after a person-centered and planning process and service plan. And I apologize for the typo on the slide. It says provide, but it must be provided pursuant to a person-centered planning process and service plan. Now, this process needs to include the people chosen by the individual, such as the person's family members, their caseworkers, trusted individuals in their lives. The person-centered planning process must also allow the person to make informed choices and must be reviewed periodically. This planning process has, in the final rule, a conflict of interest provision. And that provision says that service providers themselves are not supposed to be part of this person-centered planning process. If the plan is going to include services to be provided by a particular organization, that organization can't be involved in the process unless you're in a situation where there's really no other viable options and the state has a robust conflict of interest policy in place. This means that people can't be steered or diverted by service providers into accepting services from that provider. The person's informed choice needs to be what determines who provides the services. Second requirement of the new final rule is that settings have to be truly community-based. Among other things, they need to maximize opportunities to seek employment and work in competitive integrated settings. We're going to be focusing on that in the context of this webinar, because most of these non-residential home and community-based services, or many of those non-residential home and community-based services, are going to be relevant to the person's ability to seek employment and work in competitive integrated settings. In addition, the sort of settings have to allow the person to control their personal resources and receive services in the community. The settings have to be consistent with the person's right to choice, privacy, dignity, respect, and freedom from coercion and restraint. And they have to facilitate autonomy, independence, and choice of services and supports. What we're seeing here is a focus on the experience of the individual rather than any specific model of service provision. We really want to make sure that the person's overall experience is one of community integration and freedom from the types of restrictions that we see in institutional settings. The final rule included some additional requirements for residential settings that are owned by the service provider. We're thinking here of group homes or other housing situations where the person providing the housing is also the person providing the service. However, these regulations also applied to non-residential settings, including places where people receive employment supports. CMS is going to issue additional guidance explaining the way that this guidance, this rule is going to apply to non-residential settings. But in the meantime, we can look at the rule and sort of come up with some basic restrictions that are going to govern non-residential settings as well as residential ones. And what are we talking about when we talk about non-residential settings? They include adult day health services, also known as adult daycare. Many of these services have historically been provided in settings that are segregated. If you look up the Department of Justice's report after its investigation of Rhode Island, and I believe that the downloadable slides will include a URL for this. You can see that there's a hyperlink here. That report really went into some pretty good detail on how these adult day settings often had the effect of segregating people from their communities during the day while they were participating in these services. They also include habilitation services. Habilitation services can be home-based, and in that case they would be in a residential setting, but they can also be sort of day habilitation services. These services are often center-based in some states. So a person will leave their residence and go to a center that provides these services, usually or often in an environment that is sort of the main people in that environment are either staff persons or other people with disabilities. But day habilitation, as we'll discuss later, does not necessarily have to be center-based and can be integrated into the community. They also include expanded habilitation services. These are pre-vocational services which would prepare a person for paid or unpaid employment. Pre-vocational services are going to be distinct from supported employment services or other sort of job-focused services because they're not focused on job tasks or specific employment objectives. They're focusing on general skills that increase employability, like following directions, attendance, task completion, and safety. Pre-vocational services cannot be paid at more than 50% of the minimum wage. The person will either be in a volunteer position or other unpaid training, or they're paid at some fraction of the minimum wage. Expanded habilitation services can also include educational services that might help someone achieve an employment goal or other goal. And supported employment services. Supported employment services can be, for example, job coaching or assistance that helps the person find or maintain employment. Many sheltered workshop services, which again are center-based, are billed as pre-vocational services. So these settings are going to be, if they use pre-vocational services funding through Medicaid's HCBS, some states' Medicaid HCBS program, these services are going to be impacted. The regulation will affect them. Some states, like Oregon, have already announced in their transition plans that they're going to wait for additional guidance from CMS on non-residential settings before they determine whether their existing employment services or other non-residential services need modification. But as we're going to see, there is quite a lot that you can take from the final rule itself just on its face without necessarily having to wait for additional guidance from CMS. That guidance is going to be extremely valuable to states, but especially for states that are having to prepare to submit their transition plan now. We would advise you to sort of look at the final rule itself and make sure that the clearer provisions of the final rule, the ones that are intended to apply to residential and non-residential services, make sure your non-residential settings comply with that rule. Now, what requirements are these? They are going to include the requirement that we just discussed, that the setting in which the person receives services is integrated in and supports full access of individuals receiving Medicaid HCBS to the greater community, including opportunities to seek employment, work in competitive integrated settings, engage in community life, control personal resources, and receive services in the community to the same degree of access as individuals not receiving Medicaid home and community-based services. The requirement that the integration be to the same degree is, as CMS pointed out, relevant to the type of community that the person is living in. So in CMS's commentary on its final rule, it said that this provision means that if you're in a rural setting or you are working at home and your interaction is limited as a result with the community, but it's not for a disability-related reason, then the setting can still be considered community-based. So a person with a disability can still receive supports in order to work at home, just as long as their working from home experience is sort of similar to that would be experienced by a non-disabled person working at home. They could also receive supports to work on a non-disability specific farm. And so if they are going out to work in a farm, maybe it doesn't necessarily, that setting might not be in walking distance to a whole range of other community socialization options to the same extent that they would have if they were working in an urban environment. But because they're integrated into the community to the same extent as other people working on that farm who aren't disabled, that's going to still be a community-based placement. CMS has also clarified in its final rule that the person is not required to seek employment, but if you, my interpretation on reading the final rule, it does not give an explicit authorization to let the person waive the opportunity to seek employment or control personal resources in the future. This is a very important distinction. we are seeing, you know, in that final rule, there are times when CMS will say that a person can waive or otherwise modify a setting, but we are not seeing any such exception to the requirement that people have opportunities to seek employment or control their personal resources. These personal resources could be their finances, their property, or other similar assets that the person might have. Segregated, the implication of this fact that you can't waive the opportunity to seek employment in the future is that if you have a placement in a day setting, there's a very poor track record of placing people in competitive integrated employment, that might not be considered to provide adequate opportunities to seek employment or control resources in the future. Similarly, if a day service sort of doesn't have a policy of allowing people to use their supports to seek employment, then that might be a problem under this rule. Again, this isn't something that CMS has clearly stated, but it's something, it's an interpretation of the rule that states might want to keep in mind when forming their plan. Someone actually asked in chat, and I'm going to discuss, I sort of put it off until this slide, is that opportunity to control personal resources is going to be very important in the context of supporting people in employment. If you are providing a pre-vocational or a supported employment or habilitative service to individuals in order to help them work, those services have to also, to the extent that it's relevant, help the person control their personal resources. If the person is going to be drawing a paycheck or receiving other kinds of payments or benefits from their work experience, they might need counseling in financial competency in order to manage their benefits and finances while earning that paycheck. We would want the service to not rely entirely on representative payee arrangements or conservatorships in order to assist that person in managing finances. We have to make sure that they're given the most opportunity and support that they can have in order to make these choices themselves with adequate support while earning their paycheck. The conflict of interest provision in the final rule is also one that straightforwardly applies to both residential and non-residential settings. In the final rule, it really didn't specifically limit it to one kind of setting. This means that providers of HCBS services for the individual can't be part of the person-centered planning process unless there are conflicts of interest provisions. So if you have a sheltered workshop operator or even a service provider that also operates a sheltered workshop or provides other kinds of employment services, that entity or organization is going to have to be either not a part of the planning process, or if they are part of the planning process, they're going to have to ensure that there are significant conflict of interest provisions in place so that people aren't just diverted into receiving whatever services that provider offers. The informed choice provision in the rule requires that individuals have the opportunity for informed choice during the person-centered planning process. The options have got to include non-disability specific settings. If the person is being offered only employment or employment supports or habilitation in a disability-specific setting, that's not going to comply with the final rule. Finally, we can, this is just a prediction, but the CMS final rule set forth some fairly specific standards that will apply to residential settings that are owned or operated by the provider. Recipients of home and community-based services funded, HCBS-funded services have got to have the same rights as tenants, a right to privacy, a right to control their own schedules and activities, and a right to accessible structures. And some provider-owned settings like hospital or nursing facilities are automatically not home and community-based services. There's a strong presumption that these would not qualify for HCBS unless the state goes through sort of a waiver process and gets it approved by CMS. And that waiver process is going to require them to prove that there's something very different going on in this setting that is just not what you would expect for a service to be provided in this kind of setting. CMS, I'm sorry, I'm going back to my earlier slide. When you look at these requirements that CMS applies to these provider-owned or operated residential settings, there's sort of two relevant themes that you can see in that. They're making sure that people have the same rights and protections as other people in similar situations. So if someone has the right, if the state law provides certain rights to tenants in a residential setting that is not disability specific, CMS is basically saying that the person living in a provider-owned residential setting has got to have the same rights as others in that community. It's also making sure that people have an experience of autonomy within this setting that is comparable to other people living in the community in their own home, that they're able to control their schedule, that they're able to decide how their time is spent, and that certain kinds of settings like a hospital is just not ever going to, more or less never going to be like that. By analogy, it's very possible that when CMS issues its further guidance on non-residential settings, it's going to follow a similar pattern. So, for example, along the lines of autonomy, CMS might require a sort of parallel provision to the ability to set one's own schedule by saying that the person needs to have the ability to set employment goals. Now, most employees don't have unlimited autonomy to decide what they do during the day. That's decided by their employer and what needs to be done. But most workers have the ability to decide, what kind of field they want to work in, what their employment goals are. They're not necessarily forced to do a job that they have no interest in when they can instead get another job that they would prefer. So CMS might require that people be allowed to set their own employment goals. Just as the residential setting needs to be compliant with the ADA and the Fair Housing Act disability protections, CMS might point out that the workplace or educational setting needs to also be ADA compliant. The person needs to receive reasonable accommodations that they might need in order to do their job, and that the workplace is fully accessible. Just as it requires that people be covered by protections similar to the rights of tenants, CMS might require that employment or pre-vocational settings comply with relevant employment laws like the Fair Labor Standards Act or the Family Medical Leave Act. And these standards, again, are going to be supplements to other requirements that are already included in the final rule and already apply to both residential and non-residential settings. For example, the requirement that people need to access non-disability specific settings and competitive integrated employment. Many states, as I noted earlier, only a few have submitted a transition plan as required by CMS in its final rule. The due dates are rolling, so only a few states have been required to submit one yet. But as I noted earlier, Oregon basically said that they were going to wait on further guidance from CMS before making any plans with respect to its employment program. Tennessee, on the other hand, has actually sort of charged forward, and it submitted a concept paper on May 30th, 2014 that discusses in some detail its plans to modify its employment program. It's got an employment program that it wants to create called Employment and Community First Choices. It's actually a dual Employment First and Housing First program that's geared toward promoting and supporting integrated competitive employment and independent living as the first and preferred option for all people with intellectual and developmental disabilities. It actually plans on operating this as a managed long-term services and supports program. Consumers under the proposal would be able to choose from 3 models of service delivery. The first one is consumer direction, where the person manages his or her own support budget. The second is a health home agency with choice, where the person selects a provider who will help direct services. And the third is sort of basic managed long-term services and supports. The Tennessee program would provide preparation and transition services to youth with disabilities under age 21. It's going to provide employment supports to adults regardless of whether or not they're at the nursing facility level of care. And it will at first target new HCBS recipients and then will be potentially expanded to opt-in by existing recipients. These existing recipients have already been receiving employment first services through another program. The services that Tennessee is going to provide will be following the general employment first model, which focuses on sort of placing a person in competitive integrated employment with supports instead of putting the person in extended training or pre-vocational programs until they're determined to be ready for employment. The theory is that competitive integrated employment is achievable for all people with disabilities who want to work, and that with sufficient support, people can learn on the job. And this model has been found to be very effective at supporting people and achieving long-term competitive employment outcomes. I'm going to quickly summarize a few other considerations as well that are going to influence not only CMS's guidance, but also just what it means in practice to provide home and community-based services to people with disabilities. CMS, although it's not the primary enforcer of Title II of the Americans with Disabilities Act in general, it's required to administer and issue guidance to state Medicaid agencies that are consistent with the Americans with Disabilities Act as it applies to public services. Title II of the Americans with Disabilities Act requires that states who offer public services to people with disabilities offer those services in the most integrated environment appropriate to those people's needs. Now, in general, in the past, enforcement of that requirement has been focused on residential settings, and that's in part why we see a lot more discussion of what community means in a residential context in policy spheres than we see in non-residential settings. But the Department of Justice has, in recent years, been expanding its enforcement of the Americans with Disabilities Act to services in non-residential settings. In 2014, this year, the United States settled a lawsuit against Rhode Island with a consent decree that requires the states to phase out sheltered workshops and increase their supported employment services. These services are going to include, as I just mentioned, job coaching and intensive supports on at the work site to help a person achieve success in competitive integrated employment. And it's going to it could also include supports in skills such as financial management or timeliness or these sort of general workplace skills. The United States versus Virginia, which was not solely an employment lawsuit, but included residential components as well, requires the state of Virginia to provide supported employment to people with intellectual and developmental disabilities who are transitioning out of institutional settings or at risk of being placed in institutional settings. And a pending lawsuit in Oregon, the Department of Justice issued a findings letter saying that segregated employment services violate the Americans with Disabilities Act. Someone just asked whether there's going to be a time limitation on a person's use of a job coach. I do not believe that there is a strict time limitation in receipt of supported employment services, but if the service is characterized as a pre-vocational service, then there will be a time limitation. It is going to really depend on how the person's use of a job coach is funded. Ideally, we would not see a time limit on a person's use of a job coach when they are being placed in a competitive integrated environment. But in practice, the projects that I have seen show that people with disabilities often really reduce their reliance on job coaches very fast as employers and coworkers step up to help the person, and as the person gets the hang of working in that environment. So a person's job coach would not necessarily need to be indefinite. I also got a question that asked whether converting sheltered workshops into affirmative business models with employees, integrated employees and paid minimum wage would be acceptable and meet CMS guidelines. And the answer is that if the workshop is in fact integrated and pays minimum wage, then it is possible that would meet the guidelines. Now, again, you have to go back and look at the requirements, and the requirements are that that we offer access to competitive integrated employment. If it is competitive and if it is integrated and pays a minimum wage or at least the same wage as non-disabled employees working on the same job, then that would probably be considered competitive and integrated. But you would really need to make sure that it is truly integrated, that the employees with disabilities are not segregated into a different part of the employment setting, that they're not, if the employees are with disabilities are doing all different jobs from the employees without disabilities, that could also be a concern. But I think that you would want to pay close attention to the CMS guidelines on that point as well. Back to the Olmstead litigation, compliance with Olmstead is one of the stated goals in the CMS final rule. So in the absence, while we're waiting for further guidance, you're really going to want to look to how the Department of Justice is interpreting Olmstead as it applies to employment settings when deciding whether or not a non-residential setting meets the HCBS requirements. Also, as we heard earlier in this webinar, the Administration for Community Living, the Centers for Medicaid Services, and the Veterans Health Administration have announced grants to create a no wrong door system for long-term supports and services. As well, the Department of Labor has announced $15 million in grant funding to up to 8 states through the latest round of the Disability Employment Initiative. These grants are going to support states that wish to improve their education, training, and employment opportunities and outcomes for youth and adults by refining and expanding on existing public workforce programs. This includes, for example, the American Job Centers. These grants are probably could really help states develop changes to their supported employment and employment services model to make sure that people with disabilities who are in need of employment services but aren't necessarily showing up in the same expected places are actually getting genuinely effective home and community-based employment services. So if a person with a disability shows up at an American Job Center or a one-stop, as they used to be called, then we would want to make sure that the people at that center know how to serve people with disabilities, are aware of the services that are available to people with disabilities who are eligible for Medicaid and Medicare, and refer people to the appropriate services. Other agencies are also going to be affected by this new final rule to the extent that it affects the services that are funded by Medicaid that they integrate into their service plans. For example, workforce development agencies may already be integrating Medicaid-funded services such as supported employment or pre-vocational services into their plans. Now, if they have previously been relying on vendors for these services that are not necessarily going to be compliant with the new final rule, they're going to be impacted by the transition, which is going to either take the form of helping these vendors come into compliance with their final rule by changing their business model or switching to vendors who are compliant. School systems are also going to be affected by this, as they may integrate Medicaid-funded services into their transition planning. We saw this to some extent in Rhode Island, I believe. And agencies are going to really need to anticipate the consideration and inclusion of different kinds of services, partners, and providers to keep up with this change in what Medicaid will and will not fund as a home and community-based service. I am going to, I know that there are a lot more questions that I will continue to answer at the end, but right now I would like to give the microphone to Rebecca to discuss in further details the opportunities for the workforce system.
Thank you so much, Samantha. This was just wonderful information and so much to think about. As Elizabeth said in her opening, the mission of the LEAD Center is to promote individual and systems change that support employment outcomes and economic advancement. And one of our major areas of focus is to work closely with the workforce system and specifically with American Job Centers as a way to promote employment. There are fabulous resources available to any job seeker through local American Job Centers. They exist in every community, and they're enormously underutilized by the disability provider community and by people with disabilities themselves. There was mention both in Annette's presentation and in Samantha's about the Disability Employment Initiative, where many American Job Centers have made a commitment, and more than 20 states have DEI grants. There's another DEI grant opportunity for round 5 that some states are providing for now. But the final rule and multiple initiatives that Medicaid is promoting offer new opportunities for providers to partner with the workforce system and for community-based organizations to find ways to work together, and for American Job Centers to find Medicaid agencies to be able to support people who may be seeking jobs. Part of what Samantha talked about in her presentation was the emphasis on full access to competitive integrated employment. American Job Centers exist to connect job seekers with competitive integrated jobs, so they are experts in that area. One of the things that many American Job Centers offer is integrated resource teams. And here again, there's an opportunity for the Medicaid-funded agencies to become part of integrated resource teams to support someone who is looking for employment and to be able to use the resources that are available from American Job Centers. Another is to collaborate and figure out ways to blend and braid funds and resources to support customized employment and discovery as an assessment method in the American Job Centers. Many of the AJCs are implementing customized employment or are working with community agencies to be able to use customized approaches to enable people who are facing barriers to employment to negotiate customized jobs with employers. AJCs don't necessarily have the resources to do that alone, but the long-term support system does. So being able to combine resources and collaborate using customized employment is another great opportunity that's available and will help agencies to comply with the new requirements. There are ways to connect eligible job seekers with disabilities to Medicaid buy-in programs, and Annette discussed what the buy-in programs are and mentioned that 45 states have Medicaid buy-in programs that kind of remove one of the disincentives that people fear in losing their benefits by allowing people to pay a monthly premium to earn more than Medicaid usually allows so that they can continue to get that kind of support, allowing them to have increased earnings, increased savings, retirement. It changes what's counted as income. Another opportunity in the workforce system is to design career pathways, is the design of career pathways to increase the availability of frontline workers for Medicaid programs. The newest Disability Employment Initiative request for proposal that's out has a focus on career pathways and enabling people to enter the workforce and to work in allied health programs. So it's another way to enable job seekers or people who work with job seekers to be successful and to have access to additional resources. We've also made available some resources. Earlier, Elizabeth gave you links to previous webinars on this topic. Medicaid also has posted questions and answers on the final rule on their website, and you have the hyperlink here. On March 20th, CMS released a toolkit, and while it doesn't include specific information on employment settings because the sub-regulatory guidance hasn't come out yet, it was developed to help comply with the requirements. And as Samantha highlighted, there are some things that, will absolutely carry over between the residential and the non-residential. And there's another link for additional information on the new regulations that have been provided. We have many questions. Before we pose our first questions, I was wondering if Annette had any comments based on the presentation or anything to add at this point.
No, I just added something via the chat box, given that Samantha also mentioned the No Wrong Door funding opportunity announcement. I wanted to make sure folks knew that the deadline for that was July 15th, 2014, and that it's available on the web if people want to take a look at it. And we're really excited about sort of the response we've received from states that are already on track on this thinking and would really use the resources to help them move forward with the development of No Wrong Door system and really engage more as more full partners, state agencies and the Medicaid agency in developing the model. So I just wanted to make sure folks knew that that was available for them to review.
No, we appreciate that, and that's another wonderful resource that people should know about. Thank you so much, Annette, for all the information you provided today. And now we're going to turn it back to Elizabeth to open it up to questions.
Great. Thank you, Rebecca. Thank you, Annette. And thank you, Samantha. This is really an amazing amount of information. But we know people still are hungry for more with the number of questions that have come in. So we're going to, if we don't get to your question, please know that we'll capture it and we'll have one of the experts on the line today answer it, and we'll post a Q&A with the archive of the webinar. So if your question doesn't get answered in the discussion, please know that we'll do every attempt possible to get it answered and posted with the archive. So Samantha, here's the first question. It kind of goes back to where you started with the final rules. It asks, please clarify the conflict of interest provision. If the service provider is not allowed to participate, who is responsible for the planning and the implementation of the plan?
So the planning, according to the final rule, can be performed either by another service provider that just sort of takes itself out of the running. It's not that you can't have a service provider involved in planning. It's that the same service provider who provides the services under the plan can't be the one that does the planning. So a provider that provides case management services or social work services can be involved simply in order to ensure that the person has access to information about the other kinds of services available in the community. And as I noted, there is a little exception that if you're in a community with very few providers and there's no feasible way to do the person-centered planning process without involving the same provider who's going to provide services, there is an option for the state to create a conflict of interest policy that ensures that the person providing the case management and person-centered planning process functions is sort of insulated within that organization from the people providing the services. So they just don't have any incentive to direct the person to services provided by this organization. So that's the basic answer. It's either another organization or you can have a person within the same organization providing the services as long as they're insulated from conflicts of interest.
And this is Annette. Can I just add something? Can you hear me?
Absolutely, yes, please.
Okay, sorry. One of the things that's sort of to complement what Samantha is saying is that so there was a conflict of interest provision that was part of the 1915I rules, and then there was conflict-free case management that was developed as a structural change requirement under the balancing incentive programs. So while the terminology is different and technically they I guess can be described differently, it's helpful, I think, for you if any of you are interested. There was some conflict-free case management guidance published through the Balancing Incentive Program. In fact, I led the development of that, so that's available on the web, and it really describes some of the key fundamental ways that, particularly in a managed care environment, how states mitigate risk. What are some ways for them to know that they're meeting the conflict-free case management requirement and mitigating the risk of directing beneficiaries back to their own business model? So, I mean, it's creating firewalls and things like that. So there's an understanding that it gets complicated in a managed care environment, so there was no intention to tamper with some highly performing and functioning systems out there. So if that's helpful for folks, that is available on the web.
Excellent. Great resource, Annette. Thank you. We have many questions about this definition of what would be integrated employment and what would be an integrated setting. So I'm going to try to utilize one of the questions that was submitted and see if that can get to the heart of it. But we may still have others who want greater clarification. The individual notes that that in the Department of Labor, the Department of Justice Rhode Island agreement, work crews and enclaves are not considered to be compliant. And that there's language from Department of Labor and from ODEP that notes that true integrated employment occurs when individuals are paid directly by the employer. So the individuals, and many of the individuals on the line today, are wondering, will HCBS setting guidance have a similar standard for integrated employment settings? Is there some understanding of what folks can expect will be the parameters for what's considered an integrated employment setting?
So my opinion is yes. CMS is required to and plans to ensure that their guidance is consistent with the requirements of the Americans with Disabilities Act as set forth in Olmstead and related litigation. So we're going to, I would anticipate that CMS will be working closely with DOJ and the Department of Labor to make sure that they're not working at cross purposes and that they're taking a consistent position with regard to what Olmstead requires and integrating that into their guidance on settings. Now, enclave crews and similar work crews are not going to be considered fully integrated into the workplace because are generally sort of isolated from the overall working environment, and they're still seen as separate from other employees at the employer. This doesn't necessarily mean, though, that people will have to be interacting with their coworkers all the time if they just happen to be in a job that is not necessarily one that's extremely social. So as CMS noted, the requirement is that the person be integrated to the same extent that another person not receiving HCBS is integrated. If someone's job is a storeroom job and everyone doing that storeroom job does it mostly sort of on their own, then that's not necessarily going to be considered the same as an enclave crew, provided that their interaction with employees is the same as anyone else who would be doing that particular job, and provided that the employer isn't sort of purposefully diverting all of their employees with disabilities into these sort of backroom settings for the purpose of keeping them separate. So that would be my take. The other question on whether or not the person needs to be paid directly by the employer, I would say that this goes to the CMS final rules requirement that people be given the opportunity to control their finances. If you have a model where the employer is paying the employment service provider and the employment service provider sort of takes out of the paycheck payment for their services or some other way sort of controls the person's access to their paycheck, that would be an area of concern in terms of making sure that the person is given full opportunity to control their finances to the extent that any other employee might.
Thank you, Samantha. To follow up on that question, there were also several questions, or really they're questions of concern about the small population of people for whom employment may not be an immediate feasible opportunity. This is the question, folks, not necessarily the opinions of the speaker. So folks are wondering, for folks who are not going to be able to transition to employment in a reasonable amount of time, what will be their options through HCBS?
Well, CMS has made it clear that no one is going to be forced to go to work. We have the 13th Amendment of the Constitution says that you can't force people to work if that's not their goal necessarily. That's not actually why you can't force people to work. It's sort of a lawyer joke. But there are a lot of day services other than employment that will be considered home and community-based as long as they are integrated into the community to the same extent that others might, experience integration into the community. So, for example, if the person wishes to do volunteer work in a truly integrated setting, let's say they want to work at their museum taking tickets, or they want to volunteer to help clean up the park, and this is something that non-disabled volunteers do all the time, that's definitely one option. We know that pre-vocational services can include volunteer work. And, there are other day activities that a person might be able to do that are completely non-work, non-even volunteer work, like, taking the person out into the community to engage in recreational activities that, if they are actually in the community, will be considered home and community-based. Not all non-residential or day services need to be employment-focused.
Great, thank you. So it's duly noted in the comments and questions coming in that there's really two sides to this. There's the side of the service provider, and then there's the other side that's needed, which is employers. And we have a few questions about employers that are coming from folks that are interested in knowing, as an employer, what expectations are there of any impact on my business model, health insurance, workers' comp, as I look to increase my employment of people that are HCBS eligible?
Great, and just sort of, right after I finished my last comment, I just do want to emphasize that, we believe that everyone who wants to work can, with the appropriate supports, go to competitive integrated employment as long as they have the supports in place that they need. Employers, if you are an employer who operates a small business and is looking to hire more people with disabilities, some people who are getting these supported employment and job coaching services are going to be a real asset. We've seen, for example, in some states' approaches to supported employment, the person with a disability often even can bring equipment to their job. For example, we had one case study where a person with a disability actually got an espresso machine that they could bring to a workplace and say, look, I've got an espresso machine, I know how to use it, I've been trained on how to use it, and if you want to serve espresso as part of your business, here I am with the equipment. You don't even have to pay for it. So these are people who can be great assets. The job coach is there to make sure that the person integrates safely into the employment setting. So although I'm not an insurance expert, you shouldn't be seeing any major increase in your workers' comp claims or other kinds of liability insurance premiums, because the person is being given all of the supports that they need to seamlessly transition to work with and learn the requirements of their job. We found that people with disabilities often taper off of their job coach or other supports pretty quickly because they just start, once they sort of get into a routine and are doing their job, they are more and more able to just take their instructions from their boss or their coworkers and just don't really need that many hours of job coaching. So people are integrating pretty well into the workplace, and they're far more loyal employees than non-disabled employees. We find that people with disabilities end up staying at their employer for longer and reporting pretty good integration into their workplace.
Great, Samantha. Thank you so much. There were several other questions about the work that nonprofits can do to be better employers to their HCBS clients. But one question in particular stuck out. It's a question of should the current sheltered workshop be expanded to include non-disabled workers and provide minimum wage and be a for-profit arm of a nonprofit. Do you think that that would help to meet some of the HCBS requirements?
It's all in the implementation. We are seeing in states that are transitioning away from sheltered workshops, I believe New York is one of them, Massachusetts, Oregon, that many of these states are actually offering resources to people who provided sheltered workshop services to try and change their business model into one that offers competitive integrated employment. This is something that, depending on what state you're in and what the conditions on the ground look like, you know, how many people are there already offering supported employment services, it might be absolutely necessary to have sheltered workshops and other providers of employment services change their business model and start offering competitive integrated employment services. We would want to make sure, though, that they don't, you know, that the integration is true integration, that they actually have, you know, a significant, one of the commenters proposed a 20%, 80% breakdown, 20% disability, 80% disability. I don't think I can give a particular percentage. That's going to be sort of a complicated question. But we want to make sure that these are environments where people with disabilities are actually in a non-disability specific environment. It's not characterized as a place for people with disabilities. And that people are actually getting wages that are commensurate with their non-disabled coworkers.
Thank you, Samantha. We have just one more question, and then I'm going to offer a chance for Annette and Speed to give some final thoughts. But the question is, can you elaborate or give an example of the educational services under expanded habilitation?
Yeah, these are sort of, it's hard to come up with an example right now. Educational services are kind of difficult to explain. They're not necessarily going to be the same kinds of services that you see through VR, but they're going to be sort of habilitation. These are all considered what's called expanded habilitation services. So they're going to be focused on education in areas that are sort of generally promoting someone's ability to work.
Great. Well, thank you so much, Samantha, for speaking today. We really appreciate you bringing your expertise and your analysis to this conversation.
Thank you.
Annette, would you like to make a last comment before we close?
Sure. Thank you. I just wanted to say thank you again to everyone for this call. It's just been a very rich conversation. I wanted to make sure that folks knew that a few months ago, myself and a couple of my colleagues, we met with the Partnerships and Employment grantees, and they provided us some similar thoughtful questions and comments about the applicability of the rule on non-residential settings and supports. And we then summarized those comments and provided them to the CMS folks who are developing the sub-regulatory guidance. They were very grateful, they are very grateful for those comments and questions, and they are going to use them as they develop the materials that they're drafting. So certainly if there's anything that you feel like maybe you didn't get a chance to ask, or if you think that it's really important that you convey any concerns or questions, I don't know if there's a way for you to send those to the folks at LEAD, and they could certainly send them to me, and I'll get them to CMS. And just the last thing was about we have been hearing from states that they're looking to sort of close the front door to certain pre-vocational services that are offered through sheltered workshops. It's definitely a trend, and it's definitely aligned with the spirit and the goals around the HCBS settings rule. And I just wanted to make sure that folks knew that even of the information that's out now, transition planning for settings does permit the state to close the door on enrollment and either phase out or move specific service settings toward compliance. And as states begin shifting service settings from segregated, isolating settings to settings that meet the new CMS HCBS settings rule, states have the option of phasing out particular programs, such as certain pre-voc programs and sheltered workshop settings. If a state identifies these settings as being isolating, they would fall into the sort of the settings presumed to have institutional characteristics bucket. The state could submit evidence to justify HCBS funding or simply determine not to submit evidence and phase out the service in the transition plan for up to 5 years. So while some of this formal guidance is still under development, some of this information has been shared with stakeholders, and I just, in the event that folks were not aware of that. So these are things that CMS is considering in developing their guidance.
Excellent. Thank you so much, and I think that provides some great clarification for all of us on the line. Speed Davis at the Office of Disability Employment Policy, would you like to offer any final thought?
I just simply want to thank the speakers for a wonderful presentation. Good information, going to be useful, I think.
Great. Yes, thank you to each of you. We greatly appreciate your participation today. For all of you that are still on the line, the Lead Center offers a free webinar series on the last Wednesday of each month from 3 p.m. Eastern to 4:30 p.m. Eastern. My apologies for being a little over time today. We're about to launch the Employment Mini-Series, which is going to focus on improving employment outcomes for individuals with disabilities. 2 of our upcoming webinars are first on July 30th at 3 p.m., Customized Employment, Moving Beyond the Basics. We're going to have a customized employment expert on the line to speak to you about how you can take this to the next step. If you haven't had a chance to view the archives of the customized employment training we provided last year, I encourage you again to go to our website, www.leadcenter.org, and click on webinars, and you can view those archives. Also on August 27th, we're going to provide a webinar on best practices in employee retention and return to work, lessons learned from employers. We'll have on the line the U.S. Business Leadership Network and Families and Work Institute, who's just completed their 2014 National Studies of Employers. It's going to be a really interesting webinar that'll provide you some great information on return to work best practices that you can utilize in your employment efforts. I want to say again thank you to Samantha Crane, to Annette Shea, to Rebecca Salon, and if you would like to provide any comments that we can send to CMS, please feel free to email myself, Elizabeth Jennings, at ejennings@ndi-inc.org. If you didn't get an answer to your question, we'll pull it out of the chat box and post it with our webinar archive. Thank you all so much for joining us today. We hope you'll join us again next month. And thank you again to our speakers. Have a great day, everyone.
Thank you.